Be seated. Is it still morning? I'm supposed to say good morning, so if it is, good morning. Now is the time set for oral argument in cause number 1CA CV16 0087, Johnson Bank versus Donald R. Leo et al., Donald R. Leo Sr. et al. For everybody's information, these proceedings are being recorded. I don't think that's going to take anybody by surprise at this point. So in a couple of weeks, barring a failing of technology, it couldn't be human failure, it has to be the technology, we would hope that the oral argument would be available to you on YouTube if you wish to see it. Counsel, each side is going to have the standard 20 minutes to present their position. We'd ask that you respect that time period. The timer that's located on the podium will let you know how much you have left. An appellant, as always, if you wish to reserve any portion of your time, please let us know. We will try not to abuse you so badly that all your time is just taken away from you, but ultimately it's your responsibility to watch that clock and save yourself some time. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to the argument, and we always say that, and I'm always careful to tell people, couch your argument accordingly, recognizing that we have reviewed the facts of the case so recently. Counsel, when you come to the podium, I'd ask that you state your name and who you represent so that we have a clear record in that regard. And with that, counsel for the appellant, you may begin.
Good morning, Your Honors. My name is Jim Armstrong. I'm with the law firm of Sachs Tierney, and we represent the Leo appellants. Seated with me at counsel table is Attorney Jeff Proper. He represents appellates Seifert and Waller, and he has graciously agreed to cede his entire time to me for this argument. I also do intend to reserve some time for rebuttal. One advantage an appellant has, in not only this appeal but all appeals, is we file two briefs. We got to do our opening brief, and we got to file a reply brief responding to the arguments made by the appellees. I say that because I don't want to simply regurgitate what's been in our briefs. My intent here is to allow Your Honors to ask whatever questions that might be remaining based upon the three briefs that have been submitted. That said, this case concerns the mandatory requirements for pursuing a deficiency judgment following a trustee's sale of secured real property under ARS Section 33814A. Specifically, the requirement that the plaintiff satisfactorily prove the total amount of its debt on the date of the trustee's sale. In this case, that was July 3, 2013. While no Arizona court decisions address this specific requirement in this context, there is abundant authority generally discussing the burden of proving damages in various types of breach of contract cases. A burden that, as determined by this court in the Wells Fargo case, rests solely on the plaintiff. Indeed, more than 50 years ago, in the Gilmore versus Cohen case, the Arizona Supreme Court held that the plaintiff in every case must supply some reasonable basis for computing the amount of its damages and must do so with such mathematical precision as is possible from the nature of the claim and the available evidence.
Counsel, what is the trial court at the time of that determination entitled to review toward its decision?
I'm not sure what you mean, Your Honor.
Is it limited strictly to the testimony provided at the hearing?
Even if it wasn't, we haven't challenged the fact that there was an affidavit placed in evidence during the summary judgment proceedings. So even if the trial court was entitled to review that affidavit, our position is it was woefully inadequate, lacked foundation, provided no explanation for how the debt was calculated, was based on outdated loan documents, the latest of which was 29 months, had an acknowledgement of an amount that was 29 months old by the time of the trustee's sale. So assuming the trial court did have a right to look at that declaration and consider it in making his final ruling, we don't believe it was sufficient evidence to make that ruling.
And what I want to be clear on is we're not just talking about what took place at the hearing.
No.
We're talking about what was before the court, either in testimony at the hearing or the record that had been created in the course of this proceeding.
Correct. And that record consisted of basically the testimony of Mr. Parsons. And he did that in two respects. He submitted a declaration in support of the summary judgment motion, and then he testified at the hearing.
Whose job was it to challenge that then? If that's the only evidence in front of the trial court, whose job was it to say Mr. Parsons is incorrect and here's how?
I think that goes to the burden of proof. We have argued and maintained that the bank has the burden of proof in establishing the amount of its damages.
So they have to challenge their own affidavit?
No, they have to account for payments when they were made, how that affected the accrual of interest, how it was deducted, and almost everything in this case came up after the trial. It's almost like the Rand case that we cited supplementally, where the judge at the time of trial held a discussion. There was no admission of evidence. He just sat the parties down, they discussed the issues, and the judge made a ruling. And this court clearly said in Rand that that's obviously insufficient. There was no evidence, there was no record upon which the Court of Appeals could review that case because of how the judge handled it. In this case, we have a very similar situation. We have, number one, a debt amount that is 29 months prior to the date of the trustee sale, the key date, the key decision-making date.
The debt amount, as I understand it, and based on your briefing, the guarantors agreed that they agreed with the quantification of the amount of the indebtedness when they consented to the loan modification. So isn't that one date to start?
And that date was more than 3 years prior.
Oh, okay, we work it out from there.
Okay.
So that's, at least at that point, the parties agreed. It was 18 million, I think it was about 400,000 or something like that.
Right.
Okay. Then we go a little bit forward to the forbearance agreement, but that's not quite clear that your clients agreed to that amount.
Correct. I
So
think
there's some ambiguity there.
well, what they agreed to was that the bank submitted proofs of claim
Right, I understand that, yeah.
asserting an amount.
I got that. Okay, so then we get to the lawsuit and Mr. Parsons' declaration, which he does not explain how he calculated the amount of the indebtedness. But his declaration was not admitted into evidence at the evidentiary hearing on the deficiency, correct?
I think that's correct, Your Honor.
And the court did not grant partial summary judgment on the amount of the indebtedness as of the date of the trustee sale, did it?
I don't believe so, no.
Okay. So we're left with the evidence presented to the court, and based on my review of the record and reading the excerpt that we have, or the part of the record we have that is Mr. Parsons' testimony, there was the bank did not examine Mr. Parsons at trial on the amount of the indebtedness.
That's correct, and that's because he offered no testimony on the amount of the indebtedness.
It's a blank record.
Correct.
So the only evidence, well, that's not quite the right term. The only information that came up was in the in the bank's proposed findings of fact.
Correct. Which cited the 4 documents, the
Right.
4 outdated documents,
Right.
and that's all
But
it
there
did.
wasn't any type of accounting or anything that reflected where interest was accrued, what was the rate of interest, because this was a variable rate, and how it was allocated between principal and interest.
Correct. And the forbearance agreement also contemplated additional payments. It
Right.
called for additional payments. Again, after the fact, after the trial, in the post-trial motion proceedings, we then learned for the first time what the bank was claiming the amount of those payments were, something like $257,000. Through its attorney's argument in the motion papers, described how that $257,000 was applied. I think they said $100,000 toward interest, 20-something thousand toward taxes. But again, no explanation of how that affected the timing or what the timing of that application was, because Those payments were made at some point, prior to the trustee sale.
And they were made, and they were made by either your clients or others on their behalf?
Correct. The six guarantors,
Right.
correct.
So the reality is that when the bank, in its opposition to the motion to amend, said, well, surely they must know what they paid.
Right.
You don't really take issue with that. It's more how it was allocated.
What I take issue with is surely we must know does not substitute for evidence at a trial.
Right, I don't think it does either. Surely we must know. But it is really how it was allocated.
And again, just to follow up quickly, again, these were 6 people. They're not related. So it's not necessarily true. And again, there's no evidence on this. There's no record of this. It's not necessarily true that each one of those 6 people knew what the others were doing in making payments.
Is there an allocation issue with respect to the condemnation proceeds?
That was an issue as well. There was no evidence produced at trial, or I believe in the declaration either on summary judgment, that the condemnation proceeds were a part of any calculation of what the amount of the debt was as of
At least before.
And in fact, the checks were not even introduced into evidence until after the fact, after the trial. They were attached as an exhibit to the proposed findings of fact and conclusions of law.
In reviewing the loan documentation we have in this record, I did not see any provision that specified that after a default, payments were to be allocated first to interest or to principal, or it was silent on that. Is that your understanding of the loan documents?
I think that's true, Your Honor. So again, how that occurred, what happened, was never explained by the bank, by Mr. Parsons in any of his testimony. But again, getting back to everything that happened after the fact, again, it was through counsel making an argument in a motion paper. Oh, here's how we figured it out. Finally, after I don't know how many months of trial court proceedings, where again our client consistently requested documentation and discovery.
Are you now referencing their proposed findings of fact, or their post-judgment?
No, the post-judgment briefing
Okay, I didn't understand
on our motion to alter or amend the judgment. Again, this was not a surprise to them. Our clients from the beginning said, basically, prove your case. Prove the amount of your debt. Provide us with the documentation you're lying on. For example, these $257,000 in payments. Show us those payments. Show us some accounting records on how you applied those payments. This is very close to the Goldwater Bank case, the decision authored by Judge Norris. Very
and it was
similar.
so brilliant. I mean, right.
And she made us read it.
Yeah,
too,
I made
so.
him read it.
Very similar.
Give us each copies, by the way.
That was on summary judgment. There are some differences. To be
Yes,
fair.
there are differences, but the same thing happened. We had outdated records that were not brought current to the time of the judgment, the date on which the actual amount had to be calculated. And, in your opinion, you indicated, your memorandum decision, you stated that was inappropriate, that there had to be explanations of when principal was applied, how that affected the interest, the accrual of interest, and those sorts of calculations. Again, no testimony, no documents, no accounting records dealing with that.
Let's say, hypothetically, we agree with you. And then we're now going to address what do we do by way of our order. Your clients are moved in the alternative, both responding to the motion to the amend, not your clients, the bank. Forgive me. Your clients moved after the judge had made his findings of fact to amend the findings and judgment, or in the alternative for a new trial. Why shouldn't we, if we were to agree with your substantive arguments, remand for a new trial on the issue of the indebtedness, not on the fair market value, because you haven't appealed that?
Okay.
Haven't argued that.
Well, there's a couple of reasons. First, we did move both under Rule 52 and Rule 59, both furnished grounds, and under Rule 52, The appellees have cited numerous cases saying, well, if the findings of the court are inadequate, they're not specific enough, that's a reason to remand the case for further findings. In most of the cases they cited, however, it was a situation of a lack of specificity by the trial judge, not a lack of evidence. We have a different situation here. And so in the cases that they rely upon, the Court of Appeals could not understand the basis, the reasoning used by the trial court, because the trial court didn't give sufficient factual findings. That's not what we have here. What we are challenging is the underlying substance of the evidence that was presented. And again, both rules, 52 and 59, provide that as a basis for relief. And what we're arguing is, again, we made it very clear throughout this case that this was one of our major defenses, is that the bank had not documented, had not come forward with witnesses or other evidence of what the amount of their debt was on the date of the trustee sale. So they knew what was coming. They had two opportunities to establish that, both at summary judgment and at the trial, and they failed to do it. So what they're asking for now is a third bite at the apple, and we cited a...
Well, yeah,
Yes.
that's clear. Go ahead.
I was but you asked for the relief.
Yeah.
You asked for a new trial.
in the alternative.
Well,
And
so
what
if we grant you what you want, how are you harmed?
we are harmed. Okay, the other reason I think it's not going to work to send it back for a new trial is discovery cutoff. This case, the judge on 2 occasions, and we put it in the record in the transcripts that we attach, twice told the parties, we're done. No more evidence. No more exhibits. No additional testimony. Discovery cutoff has passed. And so if we're remanded, I assume that order still stays in place.
No, it doesn't. No. I mean, a new day has dawned if we remand for a new trial on the indebtedness, but not on the fair market value, because you haven't appealed that.
Okay.
And that's an issue that I think has been decided.
And you know, again, I think the fact that they failed to produce that evidence, my suspicion is it doesn't exist.
Well,
why would you not have done that?
Well, there's that. But other than your argument that they shouldn't be allowed to make up for a deficiency a third time, which has maybe some equity to it, but perhaps it's not legally a legal argument. Is there a legal argument as to why, since you moved in the alternative for a new trial, we shouldn't, if we were to agree with you, we cannot grant you what you asked for, which is a new trial?
Okay.
Is there some legal impediment to that?
The truthful answer is I do not know.
Okay.
I don't know if there is law that addresses this precise situation where there is an alternative basis. You know, what latitude your honors have in deciding which basis to choose. I don't know the answer to that. What I do know is we cited a number of cases, the Crouch case, the A.R. Teeters case, United Producers, United Dairymen. This is all a reply brief at pages 25 to 26, addressing this situation. That is, a remand is not intended for you to make up a gap in your evidence. The fact that you had a full opportunity to put on your evidence and didn't do so, and for that reason the judgment is reversed, that does not justify another bite at the apple where you can now go back and fix it. Because there was nothing preventing you on the original time around, and in this case twice, 2 opportunities in the original time around, to put in that evidence. Unless your honors have any other questions, I'd like to reserve the rest of my time.
Thank you,
Thank you.
May it please the Court, Timothy Berg of Fenimore Craig on behalf of Johnson Bank, which I'll refer to as the bank or the lender in this argument. I think it's important to note what's at issue on this appeal and what's not. There's no dispute that the bank made an underlying loan of $21 million. There's no dispute that what I'll call the guarantors guaranteed that loan. There's no dispute that the borrower didn't pay the loan. There's no dispute that the guarantors haven't made any payment on their guarantees. There really is no, as Judge Norris has pointed out at this point, no dispute about the fair market value of the property, because Judge Gama held a hearing at which evidence was taken, and the guarantors haven't appealed that.
Counsel, you've got to admit that in the case of this scope, showing how you calculated the interest and applied, let's just leave it at interest, but how you calculated the interest plays a big part. So point me to where that was accomplished so that we can all understand what the court was basing its decision on.
Your Honor, our position would be that the evidence we put in the first place, Mr. Parsons' declaration, the recital in the loan modification agreement, the recital in the forbearance agreement is sufficient in and of itself. And that if plaintiffs wanted to challenge how we calculated those numbers, it was their burden to do so.
Mr. Parsons' declaration was not admitted into evidence at trial.
Well, but Your Honor, you're treating the 33814A hearing as if it were a trial on the underlying liability or even damages, and it's not. It's something entirely different. If you read 33814A, what it is it's a hearing on a deficiency judgment amount with a determination of what the fair market value is. In fact, the fair market value, what 33814A does fundamentally is create a right for a debtor or a guarantor to have its deficiency, what would otherwise be the deficiency between the amount of the debt and the credit bid at the hearing, changed because the fair market value of the property is higher than the credit bidding. It's in the nature of an affirmative defense on the part of the guarantor or the borrower that whoever bought the property at the trustee sale paid too little and I'm entitled to a higher credit. It isn't a trial in the traditional sense of Mr. Armstrong keeps relying on all these cases relating to breach of contract and what's supposed to happen at a breach of contract trial, and that's not what was going on in this case. What happened in this case was summary judgment was entered on liability, and then we had a hearing on the amount at which they had a right as a defense to prove that the fair market value of the property was something higher than the amount of the credit bid.
How are they going to be able to question the amount of the indebtedness in light of the record evidence that the bank wouldn't provide any backup material showing how they calculated the number? And I might add the number, the indebtedness number, varied from time to time. It was the loan modification was one number, the forbearance agreement is another number, the complaint had a third number, Mr. Parsons in his declaration had another number. So how are they supposed to figure all this out?
Well, Your Honor, you look at what could have affected it, and the answer is it was payments by them.
But how? It's a variable rate of interest tied to an index that is fairly unique within the bank. That's not specified, and so how would they know what that index rate was at points in time? How would they know that?
Your Honor, this is a $20-some million transaction,
sure is. Yeah.
And I would suggest to you that if you borrowed $20-some million or I borrowed $20-some million, we would know what rate of interest we were paying.
No,
we would
Trump's
monitor.
Tax
We'd monitor.
Returns. How are we going to know that?
If it's LIBOR or it's prime or it's something like that, we would find out what it is and pay attention to it.
It's not. It's the bank's index rate plus 1% before the default or 6% after the default. But this is a huge loan. I couldn't agree. But you have that whole issue. And then, of course, Mr. Parsons in his affidavit at least didn't take into account initially the condemnation proceeds, or they're not mentioned, didn't take into account the additional payments made by the guarantors. There's never been any explanation of how the bank was going to allocate that, except that came after the fact. And then there's some money that was paid for property taxes, but we don't even know how that's implicated in all this. Nothing is proven up. It's just attorney argument.
Your Honor, I guess what I would suggest to you is that when we put in evidence that the amount of the debt on the date was, I think it was $18,490,247.78. I'll get it right if I try long enough. That's sufficient evidence to get a judgment in that amount.
What
and
happens
to the
Wells
extent that
Fargo case?
let me come to that in just a second. To the extent that there
just so
are.
I'm clear,
Yes.
when you say that there was put in evidence, are you referring to the testimony that was?
No, I'm referring to the declaration, Your Honor, that was submitted at the time of motion of partial summary judgment.
All right,
I apologize if I wasn't clear on that.
Said it was put in evidence.
Yeah,
and I just-
from our position, given that this wasn't a trial, it was a different kind of hearing. Our position would be what was in front of Judge Gama as part of the summary judgment papers was something he could consider in reaching the judgment in the deficiency hearing and ultimately entering judgment in the case. And so when I say evidence, I mean what was in front of him, both at summary judgment and at the fair market value hearing. So to the extent that the judgment then is lower than that amount, that's an error in their favor. And if they didn't offer any evidence to produce a lower number, I guess, Your Honor, my answer to them is they could certainly have been held liable by Judge Gama for $18,490,247.78. And the fact that afterwards additional deductions were made that lowered the amount to them is not something that they're entitled to complain about. And we make this argument in our brief.
Now, let's go back to Wells Fargo then.
Okay?
How do we
Yes, you're right.
square-
I did promise you I'd talk about that, and I almost
appreciate
walked
that.
away from it.
And you're always a man of your word, I know that. How do we square Mr. Parsons' declaration with the requirements in Wells Fargo?
Wells Fargo involved an affidavit by somebody who was no more than a custodian of records. And that paralegal, my recollection is that the paralegal testified as a custodian of records and said, I've been through the bank's records and here are what they show. Our position would be Mr. Parsons is different. He isn't a custodian of records. If you read his declaration, he says, I am the person responsible for managing and collecting this debt at the bank. And that gives him personal knowledge of in a way that someone who is simply a custodian of records would not have.
Isn't that a distinction without a difference?
I don't think so, Your Honor. It clearly is a distinction. I'm not telling you that there, what I'm telling you is what I think the difference is between the Wells Fargo case and this case.
Mr.
I think
Parsons said, I have access to all the records, and I made this determination as the custodian of records. Or as the person who's responsible, I get the paycheck along with the title. Okay. And the other guy says, I'm the custodian of records. I'm responsible for making sure that these numbers were right for purposes of these proceedings. Aren't they both equally suited at that point? One may get more money than the other, but aren't they equally suited to address the issue? No, especially when the bank is putting them forward as an authority on that issue.
Your Honor, my answer is no. If you read Mr. Parsons' declaration, the first paragraph says, I better come over here so I'm in front of the microphone instead of talking beside it. I am the Senior Vice President of the Special Assets Group at Plaintiff Bank. I am responsible for administering and collecting the debt owed by defendants Leo, Blondin, Seifert, Walter. And I am competent to testify as the facts set forth below. That's different than being a custodian of records. What he's saying to you is, I have personal knowledge of this because I'm the one who administers this loan for the bank. I'm not somebody that they sent over to read a bunch of records and put a number in an affidavit and tell you about that.
But don't either one of them stand for the position of the bank in regard to those numbers?
I think there is a qualitative and quantitative difference between saying I have personal knowledge because I directly am involved in and responsible for this loan, and saying I am someone the bank has keep records and I'm telling you what the records say.
So the judge in evaluating this indebtedness should decide a portion of it based upon the title of the person making the assertion.
I think on the position, duties, and involvement of the person making the affidavit in the particular transaction. I would put it a little differently than you did, Your Honor, but certainly the difference between a custodian of records and somebody who's the loan officer, the person directly responsible for this.
Mr. Burke, how difficult would it have been when Mr. Parsons was testifying to simply ask him how much was the outstanding balance?
Your Honor, hindsight is 20/20.
No.
If you asked me today, do I think it would be easier than to have spent all this time writing briefs and making argument to have asked that question? Absolutely. The question isn't, I think, in hindsight, what would one do today, knowing that we had an appeal, knowing that we spent money on appeal, knowing that we're having an argument today. I think the question is what the bank did sufficient. And I think because Mr. Parsons had put in his affidavit, they didn't need to ask him those questions on the stand. Maybe they'd have saved themselves some attorney's fees if they had, no doubt about it.
Let me ask you a question. When I look at Mr. Parsons' affidavit, he said in paragraph 9, page 3, and then page 4, that as of the date of the trustee sale, the principal on the loan document, the indebtedness for principal in the amount of $18,490,247.78. Then, when I look at what the bank submitted in responding to the motion to amend, motion for new trial, they started with that amount on the top line, deducted $128,000 for the other payments, plus the condemnation proceeds. So the reality is that his affidavit or his declaration wasn't correct or wasn't complete. So I mean, there's a fundamental lack of. When he represents, this is what was owed.
Right.
And page 3, as I read it, that is another statement as to here's what was owed, and they're materially different.
Well, Your Honor, I guess my answer to that is that if he testified that $18,490,000, I won't go through the rest of it
That's
again,
fine. You can have the
was
78 cents.
owed, and the plaintiff and the guarantors knew there were condemnation proceeds, or the guarantors knew they'd made payments, then it was their job, either in response to the summary judgment motion or at the hearing, to raise those points. And they weren't prejudiced by the failure to raise them, because in the end those amounts were deducted out of the final judgment. They got a net judgment for less than the amount that the evidence would have supported. And in fact, as we point out in our brief, they did better than that because the condemnation proceeds got subtracted twice.
But how would they, I mean, well, for those, maybe we're just going over the same ground. How would they know how, for example, the $128,000 was allocated between interest and principal? How would they know that?
Your Honor, again, let me come back to the microphone, I'm sorry. Your Honor, I think the answer is that again,
They should have asked.
they should have asked. They should have, when Mr. Parsons was on the stand at the hearing, if they had wanted to ask those questions, they should have asked them.
Well, again, what about their efforts to obtain it in discovery?
Well, Your Honor, they haven't appealed the trial court's any. In fact, I don't think they moved to compel ever. But if they did, they haven't appealed any decision. They haven't argued that the trial court should have granted them judgment because of discovery abuses. So the answer is they waive that for purposes of appeal. I think if they had a concern about the number, Mr. Parsons was on the stand, they could have asked him about it. I want to talk briefly about the issue the court raised about what's the appropriate remedy here if you conclude that the judgment isn't sufficient. I mean, that the evidence isn't sufficient to support the findings of fact. Mr. Armstrong argues that there are two different lines of cases and says all of our cases really deal with insufficient findings and not a lack of evidence. And I guess what I would ask the court to do, and I'm sure you have already, but I'll ask you to do it again, is look at Fritz versus Erickson. In Fritz versus Erickson, which is an Arizona Supreme Court case, Justice Udall wrote, I can't remember which Udall, whether it was Levi or Jesse, but one of the Udalls, wrote an opinion about, I think it's an adverse possession case. And the court remanded that case back to the trial court, both because there was insufficient evidence from which the court could make findings and because the court thought there were insufficient findings. In the end, a defect in findings and a defect in evidence, at least in a case like that, are the same. And if this court thinks there was insufficient evidence to support the findings that were made by Judge Gama, then the correct remedy, particularly since plaintiffs asked for this remedy in their motion for new trial, is to remand this matter back and let us litigate the question of what was the amount owed, what were the deductions, how was interest calculated. All of that is the appropriate remedy in this case. It would be grossly inequitable and unfair for Mr. Armstrong's clients and Mr. Propper's clients, and I'll use a colloquial term here, to get a get-out-of-jail-free card on what everybody thinks is a significant debt, as Judge Norris and I were talking about, started at $21 million. It's at least somewhere in the neighborhood of $15 to $18 million, simply because Judge Gama thought there was enough evidence to make a finding, and now the court concludes that he was wrong. Remember, Judge Gama sat through that hearing. He saw the evidence on summary judgment. He concluded, despite plaintiffs' efforts to tell him that there wasn't enough evidence to support it, he concluded there was sufficient evidence to support the finding. If he was wrong, and we certainly don't believe he was, we think there was sufficient evidence to support that finding, the correct remedy isn't to simply zero out a judgment. It's to send the parties back to try this matter in front of a trial judge with additional evidence and additional findings. It's exactly the appropriate thing to do. Now, we don't think you need to do that because we think there's enough evidence to support this judgment. But we certainly think it would be manifestly unjust and unfair to simply say when Judge Gama thought there was enough evidence, when Judge Gama thought he could make findings, when Judge Gama thought he could enter judgment in our favor, when he several times denied their request for a new trial or additional judgment, to say as a result of that, what happens is they get to walk away from a debt that, again, to go back to where I started, nobody denies there was a loan, nobody denies the borrowers defaulted, nobody denies their clients guaranteed the loans, nobody denies the guarantors didn't pay. There's simply, at most, there is insufficient evidence of the amount that should be paid to the bank. And if the court concludes that, and again, we don't concede that it's true, then the appropriate remedy is to send this back for a new trial. Let my client put on its evidence of what's owed, let Mr. Armstrong and Mr. Proper's clients put on evidence of anything they think reduces that amount. We know it won't be fair market value because they didn't appeal that, but whatever else they think reduces that amount, let everybody have their day in court. We asked the court to affirm the judgment below. We think there was sufficient evidence to support the findings of Judge Gama and to support the judgment, but certainly if you don't, the correct remedy here is a new trial on this issue. I have 2 minutes left, and I'll happily sit down because I know the other case went a little longer if you don't have any other questions for me.
Thank you, counsel.
Thank you very much.
I made a lot of notes. Let me start with a comment Judge Norris made, and that is how the principal amount differed. You know, every time we had a declaration or was in another document, the amounts differed. What differed even more is interest. Huge spreads in the amount of interest that are recited in these agreements or that Mr. Parsons testified to. In fact, I believe in his declaration, he didn't specify interest at all. He simply gave a principal number plus interest, costs, attorney's fees. So it wasn't even specified in that declaration. Going to his testimony, you know, I listened to Mr. Berg try to distinguish Wells Fargo. I don't think there's any basis for distinguishing Wells Fargo. I've never heard of this difference between a custodian of records and a manager of the account. I think Judge Jones, you even said, you characterized him saying that he had access to or reviewed the records. He didn't even say that. That's not in his declaration. And the point of Wells Fargo is that you have to describe, give some basis for how the calculation was made. And in that case, after the fact, after the affidavit was challenged, the bank came back with, you know, piles of statements, of credit card statements indicating, showing all the transactions, but there was no supporting declaration for those records, and so what Wells Fargo said is that Rule 56 requires you, if you're relying on records to provide your testimony, those records have to be produced. They have to be produced. They have to be authenticated. There has to be a foundation for them. And here there were no records, but assuming he did rely on something, some sort of accounting records, he didn't produce them. The bank never produced them. That goes to my third point. Mr. Burr, on the discovery issue, that we did request these kinds of records. Judge Norris, you asked, how are we supposed to know how the $257,000 was allocated between interest and at what point in time? And again, the answer is we did ask for these records. Not only were they objected to, but they told us in their responses, We've given you everything. It's not a situation where we, filed a motion to compel because the only thing stated were objections. There were representations in their responses that we've given you everything.
Counsel's position is it was your job to ask.
We did ask.
At the hearing, it was your job to drill into Parsons and get the specifics. Tell me about that.
Okay. Yes, if he had actually offered any proof at the hearing, it would have made sense, obviously, to cross-examine him. But he did not come forward with any evidence to support the amount of the debt at the hearing.
But you knew that was going to be an issue. You knew he was on the stand. You knew he purported to be the guy that had those answers. Couldn't you have just eaten him alive on those things that you didn't think he had any support for?
Well, I wasn't trial counsel. I wasn't there.
It's always a good answer.
Yeah. Again, I think it goes back to burden of proof. This is not a situation where we're obligated to establish the amount of the debt. The bank had that obligation. The bank tried in their declaration. They didn't even try at the hearing. And I don't see that as being the debtor's responsibility, their guarantor's responsibility to make the bank's case by asking, them for the information that they should have provided under the Goldwater Bank case, under the Wells Fargo case, the information that they're required to provide to establish the amount of their debt.
Counsel,
Am I done?
you're pretty close. If you want to finish up with something for us, give me your big finish.
Okay. I'm looking at my notes. The Fritz case, we addressed it in our reply brief. I just urge you to read that. The issue that there's no right to zero out, this judgment happens all the time. If there's deficient evidence, if there's, there's plenty of situations in the law where somebody owes a debt and they're not paid because legal requirements weren't followed. So I don't view this as a situation that's any different because of so-called equities. The bank had an obligation to prove its case, and it didn't. Thank you, Your Honors.
Thank you. Counsel, thank you. Thank you for your time. Thank you for your preparation to present to us today. We're going to take the matter under advisement at this time, and we will issue a decision in due course. We're adjourned.